The new order from Judge Chutkan blocking Special Counsel Jack Smith's release of his 2-volume greatest hits set of special report totaling 1,000 pages against Donald Trump through the Attorney General. That order is likely completely illegitimate, and she doesn't have the jurisdiction to enter that order. And if I were the U.S. Attorney for Miami, I would immediately object to it to the 11th Circuit and move to vacate the order and get those reports out to the public. I'm Michael Popok. You're on the MeidasTouch Network and Legal AF. Let me break it down for you. I don't know for the life of me, and I practice in Florida, I practice in the 11th Circuit, and I practice in the Southern District of Florida. I don't know for the life of me where Judge Chutkan gets off, what jurisdiction she believes she has to block those reports. Let me explain it to you. The judge has to have jurisdiction over a subject matter in order to issue an order. It is fundamental. Without it, if they're just sort of casual observers of a case, they can't issue an order. Let's leave aside for a minute whether a federal judge can cross over, breach separation of powers, and stop the executive branch from issuing statutorily mandated reports. I don't think she can do that either, and she has been chastised and reprimanded by the 11th Circuit in the past for crossing over and violating separation of powers and violating the powers of the executive branch and stopping them from doing their prosecution. But also, she has no parties in front of her because the entirety of the entirety of her case that used to involve Donald Trump and his co-conspirators in Mar-a-Lago, Walt Nauta and Carlos de Oliveira, is up at the 11th Circuit. She has no, which for me divests the trial court judge of issuing any more orders in the case. She has no case in front of her in which to enter any orders anyway. That now resides with the appellate court at the 11th Circuit. I mean, she dismissed the indictment. Let's all remember, she did the extraordinary thing of dismissing the indictment against Donald Trump and the other two, claiming that the special counsel was invalid, unconstitutional, illegal. She violated 200 years of precedent about how we appoint special prosecutors and independent counsel through the Attorney General's appointment process. She violated that. She also found that the funding, the $20 million of funding for Jack Smith, was somehow unconstitutional and illegal. Okay. We all disagree with that decision, and the 11th Circuit has it up on appeal, but the case has now moved. It has now been transported out of her courtroom in Fort Pierce, Florida, to the 11th Circuit in Atlanta. And the only two parties in front of in front of the 11th Circuit is de Oliveira, the maintenance worker, and the valet butler guy, Walt Nauta. Trump has already been dismissed from the case. And we know that the heart of the release of these reports is really against Donald Trump, both in the Chutkan D.C. election interference matter and in the Mar-a-Lago matter. So how is the tail wagging the dog, and how does this judge even have jurisdiction? I would posit that she does not have the jurisdiction, that it was divested when the case went on appeal and when Donald Trump was dismissed from the case by the Department of Justice Special Counsel several weeks ago after the election. If she doesn't have any jurisdiction, she can't issue that order to block. Now, I don't think the U.S. Attorney's Office in Miami, who now has the case from the Special Counsel, is in any position to just ignore the order and violate it, or nor the Department of Justice. But I don't get how she blocks Mar-a-Lago, since the case is up with the 11th Circuit, and she has nothing in front of her. It is beyond aberrational and abnormal and impermissible for a trial judge whose case is now up with the appellate court in the federal system to then continue to issue orders in the case. There are no orders. She has no jurisdiction. She has no parties technically before her. She dismissed the indictment that gave her jurisdiction, and that issue is up on appeal, plain and simple. And let's go further. How does she also block the release of a matter that doesn't involve Carlos de Oliveira and Walt Nauta? The D.C. election interference case in front of a different federal judge, Judge Chutkan, doesn't involve those two. And so how does she block the release when she doesn't have that party in front of her? And let's be frank, D.C. case doesn't have Trump in front of Judge Chutkan either, but at least she was the one that was responsible for that prosecution. So this is if I were the Department of Justice, I'd play hardball. I would immediately go back to Cannon, I would file a motion for rehearing or reconsideration to argue to her that first of all, she can't block the release of the reports related to Donald Trump and the DC election interference case. She never had jurisdiction over that. But more fundamentally, I would argue she doesn't have any jurisdiction to issue any block order at all, temporarily or otherwise. I know it's a 3-day, it's a stay to block the release of the reports until 3 days after the 11th Circuit gets around to ruling to preserve appellate jurisdiction. But that's not her role. That's not her jurisdiction to do that. The 11th Circuit would have to do that. So I think if I'm the U.S. Attorney Miami, being guided by the Special Counsel and Main Justice in Washington, I file 2 pieces of paper. One with Judge Cannon, to vacate and reconsider, tell her she's wrong. It's overbroad because it's covering a part of the report, the 2 volumes. It doesn't deal with any case in front of her, and argue to her she has no jurisdiction. And that order is ultra vires and completely without any merit or any value or power. And I'd file a second piece of paper at the 11th Circuit Court of Appeals. And I would argue there to vacate that order. If they want to block something, barely, they could maybe block the Mar-a-Lago side of the report, but they couldn't block the DC election interference case. They never, even the 11th Circuit didn't have jurisdiction over that. And then you have this whole separation of powers issue. Separation of powers is we have 3 co-equal branches of government. There is a branch of government called the executive branch, which in this case is Article 2. And Article 2 powers of the president and his Department of Justice says by statute that was authorized by Congress, says that the special counsel must prepare a report and that the attorney general must release that report if it's in the public interest. That's a statute. That's a law. That's not open for interpretation or being blocked by a federal judge. Now, I know their argument is, well, on the Trump side, well, the special counsel's invalid, unconstitutional, so anything that comes out of him is invalid and unconstitutional, including those reports. Throw that in the trash too, just like the indictment. But that's not how the law works. That's not how the declaration works. That's not how the dismissal works. And she has no jurisdiction or power fundamentally to order that block. I'm going to continue to follow it. We're going to see what the next chess moves are. Follow it right here on the MeidasTouch Network and on Legal AF. While you're at it, head over to Legal AF, the YouTube channel. Hit the subscribe button. We're trying to get to 500,000 by our half birthday. We're already at almost 400,000 in just less than 4 months. So help us there. The bigger we get, the more your voice is heard. And we appreciate you. I appreciate you. See you on my next Legal AF contribution on Michael Popok. In collaboration with the MeidasTouch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.